Hello, folks. As you can see, I am Ryan Casson again, and here at the beginning of this video, I'm pointing to my South Dakota law license plaque on my wall. So let's talk about that for 1 minute, folks. Again, this is attorney Ryan Casson of the law office of Ryan J. Casson here in Southern California. And yes, I am also licensed in South Dakota. Well, if I live and practice in the state of California, why would I get a law license in South Dakota? Well, as you might know from my prior videos and my website and so forth, I am an estate planner. I practice estate planning law and some ancillary areas like, tax matters, IRS disputes and bankruptcy, consumer Chapter 7 bankruptcy. So South Dakota, has its own set of trust laws, trust and estate laws, just like other states. So as Californians, if you are in California, and maybe you're not, and that's okay, and I want to touch on that, but here in California, we know that California laws are no friend of debtors. You get sued for some reason, whether it's a car accident, slander, a business dispute, breach of contract. It's tough going once that judgment is entered, whether that's a default judgment from not answering, from not defending the case, and maybe somehow you don't have a defense, or maybe it's a judge's order or a jury verdict even. Once that plaintiff, that judgment creditor, gets that judgment, they become a judgment creditor. And then they can seek to enforce that judgment against the defendant's property, your property, whether that is tangible property, intangible property, real estate, Bitcoin, crypto, etc., business interests, oftentimes via a so-called charging order. That's a whole nother conversation. That is going to create a difficult situation for you. So here in California, if you have an irrevocable trust that you create yourself, that is still potentially exposed. And we have the related issue, of this voidable transfer potential, and sometimes with the LLCs, a sole member of an LLC, an SMLLC, let's say you create your own LLC and you are the sole or only member, there are certain rules that you need to follow, and certain segregation of personal assets, personal affairs from those of the corporate entity, the LLC as a separate entity. But if it's not, it's your alter ego. And that gives rise to the so-called litigation concept of alter ego liability. Piercing that entity veil, whether it's a partnership or an LLC, it's the same type of concept that we talk about with corporations, and piercing the corporate veil. That same concept applies to your own small business that you created and managed as an LLC or potentially a partnership. If you did not follow and adhere to the formalities of that entity, you're risking alter ego liability in most states, to the best of my knowledge, certainly California, and South Dakota too. But if you do this right, if you take your business seriously and the way you deal with and manage family affairs, not even necessarily an LLC, you might have a better fighting chance at defending against that lawsuit or settling. So going to South Dakota, again, that's an entirely separate law on the books. The trust laws and case law, the statutes are different than in California. So bottom line, folks, there are a handful of states that have a solid reputation as asset protection states, where we can create, again, cutting to the chase, a certain type of irrevocable trust. An irrevocable trust that in the estate planning and asset protection world, we simply refer to as an asset protection trust. Here in the US, we call those domestic trusts. So we put those two words together, and what do we get? We get a DAPT, a DAPT, a domestic asset protection trust. A domestic asset protection trust is oftentimes created in only a handful of states, oftentimes Nevada, South Dakota, Alaska, or Delaware. So I am licensed in South Dakota. I can prepare your domestic asset protection trust under the jurisdiction of South Dakota. And I like South Dakota as well because it's further from California, a separate federal circuit. And just like Nevada, it is tried and true if set up right and maintained and administered correctly, properly. So first and foremost, what are we talking about? We are talking about a South Dakota-based trustee. You are not going to be your own trustee, and you're certainly not your distribution trustee, and we're not going to pick a random person in South Dakota. At this level of planning, oftentimes it's going to be a South Dakota trust company. So a bigger, corporate company to serve as your trustee. Perhaps you have a role in a bifurcated or segregated trustee concept, such as an investment trustee, where you have no authority over distributions, but you can have a say in how the assets are managed and invested. So a corporate professional South Dakota trustee, and that would come with a fee. So again, at this level of planning, it's going to cost you. So also we can build into that LLC planning. So for instance, maybe potentially you transfer, potentially on a case-by-case basis, you transfer a California, secondary investment property to an South Dakota LLC, and one or more of the members of the LLC is a South Dakota irrevocable asset protection trust. Oftentimes, again, if handled and managed properly, a South Dakota court would maintain and uphold the asset protection nature and protection of that framework, of that plan. However, what remains to be seen is if we're talking about property physically located, your dirt, if you will, is here in California. Is a California judge going to give deference to and respect a South Dakota's courts, a South Dakota court's finding that asset protection nature stands? That is not always clear, but again, perhaps that may give some incentive for the plaintiff, that judgment creditor, to settle. But again, that remains to be seen. So full circle, we are oftentimes talking about, I don't know, 1 to 2 million or more of cash, securities, or a value in a brokerage account to be transferred to and held by and managed by that South Dakota trustee, where those funds, $1 to $2 million or more, are held by your South Dakota irrevocable asset protection trust, of which you are not a beneficiary. So again, if you have a smaller amount of funds, a modest estate, and there's nothing wrong with that, but you may need cash flow. You have to think about that, folks. So it may not make sense to lock up and transfer a large amount of your liquidity or your net worth in an irrevocable trust under which you are not a beneficiary. And in fact, in many circumstances, that can constitute one of the many badges of fraud. If you render yourself illiquid, insolvent by transferring the majority of your cash estate away and it's transferred into an irrevocable trust, that a judgment creditor can go to town with that, because you rendered yourself insolvent at the time of the transfer. So I mean, perhaps a ballpark, rule of thumb, 10 to 20% on a case-by-case basis is what we're talking about here. Again, oftentimes, cash, liquid amounts in a cash securities or a brokerage account, that could be held by an LLC that is owned by or assigned to, this irrevocable trust. So, quick psychological, a quick psychological component here. Again, full circle, you are not the beneficiary, but what would you say if I told you your trustee or specifically a trust protector, a third party who is not the trustee, but he or she is the trust protector with certain powers in your trust? Folks, what would you say if the trust protector in your trust, and we could talk about that, has the authority to flip a switch, essentially, just like flipping a light switch? A hybrid aspect, if you will, where that trust protector or independent trustee can flip the switch in the trust and add you in, if necessary, as a beneficiary. That might make this approach or this plan sound a little bit more palpable if you don't have a spouse. So again, trying to bring this full circle in just a few minutes, so we could go on and on about this, in multiple videos or meetings. If that's what I do with my clients. So with spouses, the name or the concept we're really talking about here with these DAPTs, these domestic asset protection trusts. There's another term of art that we use between spouses, a hybrid spousal limited access trust, a hybrid SLAT. Once again, a hybrid SLAT, a hybrid spousal limited access trust. That's where one spouse uses separate property. So if you are in a community property state, such as California, we would be talking about using the trust makers, the grantors' separate property to fund the trust. So the trust maker funds, the South Dakota hybrid SLAT, with his or her separate property, and who is the beneficiary? You guessed it, it's his or her spouse. So the trust can say, the trust can use also what we call a floating spouse provision. So a hybrid SLAT with a floating spouse provision says that the spouse, whoever the spouse may be from time to time, is the beneficiary. So the trustee could make discretionary distributions to the trust maker's spouse. So if you are separated, you file for divorce, unfortunately the divorce happens, that spouse is no longer the beneficiary. And what does that mean? That means that distribution spigot, that pipeline gets turned off. So in that case, there would be no beneficiary for that period of time if you don't have a spouse. But again, if you were unmarried now, we can still do that for you. You could create a South Dakota hybrid SLAT now. It's the same thing essentially as the domestic asset protection trust. It's just that the beneficiary is whoever your spouse may be from time to time, or somebody else, a sibling or a best friend. And the trust protector can have the authority, if drafted into the trust, which is common, to modify or change the beneficiaries. So if you don't have a spouse, you can still do this now. If you have a spouse and unfortunately the marriage doesn't go as planned and divorce happens, that divorce, your former spouse would no longer be the beneficiary and you wouldn't receive distributions. Now, again, we are not doing this if you are relying on this for cash flow, as I said a couple minutes ago, as an unmarried person. It is extraordinarily rare, highly highly rare for a sole trust maker who's unmarried and they create a South Dakota hybrid slat where they are not the beneficiary. And in fact, there is no beneficiary because they're unmarried, but the trust says the beneficiary is whoever my spouse may be from time to time, but you're unmarried. And so there are no distributions. Are you going to have the trust protector flip the switch and add you in as the beneficiary, even though the trust protector can? No. That would expose the distributions of the trust property to your creditors. And again, frankly, statistically, pragmatically, in practice, this never happens. So if you're thinking that you're going to lock up your net worth, your liquid cash in this type of hybrid slat in South Dakota, which is an asset protection trust, and then from time to time, as the case may be, on a periodic basis, ask the trust protector to add you in as a beneficiary and then take you back out so you can dip into the principal of the trust, you're really not going to be doing that. That is not what this type of plan is for. So again, we're talking about 10, maybe 20% of liquid assets at $1 to $2 million at least. So that tells you about the level of net worth that we're talking about. But again, in summary, South Dakota is a whole nother planning opportunity outside of California. Excellent asset protection case law, statutes, tried and true. Very privacy oriented with trust disputes. They are private under South Dakota law, even more so than Nevada, in my humble opinion. So there are other planning tools we can use under South Dakota statutes where the trust maker, the grantor, probably you, can have a role in the decisions of the trust, but just the distribution decisions would not be yours. So if this is something that you think might work for you, whether you are a physician or you are a crypto investor that really hit a big in getting in on some crypto at the right time, and you have a crypto holdings or a business interest, perhaps you may want to consider this type of planning. And you do not need to be in California. You do not need to be a South Dakota resident. Anybody under the right circumstances, if it makes sense, can utilize South Dakota asset protection planning with the South Dakota LLCs and South Dakota irrevocable trusts. We can create that structure for any U.S. citizen who resides in any state. So I think this is a good place to wrap up, folks. I know there was a lot here. I tried to touch on some of the key points about voidable transfers, badges of fraud, the level of cash that we're talking about to fund this type of irrevocable plan. We talked about single persons, unmarried persons creating these plans, as well as married persons, and what happens in the event the divorce goes south. We talked about flexibility with trust protectors, hybrid slats, again, a spousal limited access trust for floating spouses, kind of a cool concept. So food for thought, give this some thought. Again, you do not need to be in California. You do not need to be a South Dakota resident to avail yourself of these planning opportunities, which do cost a pretty penny because this playing field is quite advanced and it takes time. So Ryan Casson of the Law Office of Ryan J. Casson here. If you are on YouTube, thank you for watching A State of Affairs and have a great rest of the day.